Investigating a state intelligence agency presents a unique challenge in administrative law. The oversight body authorized to review the facts often relies exclusively on that same agency's classified files. Classified state intelligence operates behind a literal wall. External investigators cannot simply subpoena highly sensitive national security documents. This reliance creates an administrative loop. If the targeted agency denies that evidence misconduct exists, the Oversight Committee, having no independent access, must accept that denial as a matter of record. International law provides an escalation path through the exhaustion of domestic remedies. This rule dictates that victims cannot seek help from global tribunals until they prove that every possible national path is completely closed. This creates a procedural paradox. A victim must prove they are blocked by a domestic system that is designed to quietly absorb complaints and dismiss them without issuing the formal rejections that international courts require. Without an external lever to force a legally binding response, domestic oversight remains a closed system of self-investigation. In this environment, international escalation is the only mechanism for achieving systemic accountability. The legal conflict between Hans Smedema and the Dutch state serves as a study of this exact mechanism. His case involves allegations of state-sponsored abuse and the transnational suppression of evidence. Over 20 years, traditional domestic appeals through the police, the National Ombudsman, and civil courts have failed to generate an investigation. This has resulted in what Smedema identifies as a cordon sanitaire, a total institutional quarantine around his evidence. Smedema recently adjusted his strategy by filing a formal notice of institutional fraud. This filing specifically targets the Dutch Review Committee on the Intelligence and Security Services, known as the CTIVD. This filing acts as a calculated legal trap. Smedema is utilizing the complex, bifurcated structure of Dutch intelligence law to force a definitive procedural rejection. He is no longer seeking a favorable domestic ruling. This strategy flips the administrative blockade into a tool. He is weaponizing the state's own refusal to investigate as the documentation needed to elevate the case to the United Nations. The historical baseline for this strategy is an official hearing in April 2008. Smedema appeared before the CTIVD to present his claims of a state-sponsored conspiracy. Smedema notes that during the hearing, the committee members verbally acknowledged the severity of human rights violations he described. This verbal acknowledgement was contradicted by the formal written legal record issued by the Ministry of Interior. This is the first page of the official rejection. The official conclusion legally nullified Smedema's claims. On the second page, the minister formally rules that the complaint is unfounded on all parts, specifically citing a lack of evidence, keine Anweisung. This explicit written denial created a permanent bureaucratic dead end. It provided the political cover needed for the state to ignore future inquiries. By establishing a permanent record of no evidence, the state successfully trapped the complaint within its domestic borders. It effectively immunized itself from internal judicial review. The new complaint attacks that 2008 ruling through the concept of transnational spoliation. Smedema accuses the CTIVD of fraud for ignoring external proof of evidence destruction. This highlights the conflict between the claims of the Dutch state and the records held by allied intelligence agencies. The complaint cites the Frankfurt dossier, discovered by U.S. military intelligence officer Al Rust, as proof that evidence was destroyed. A U.S. military court eventually reached a $1 million settlement, validating the existence of these foreign files. This finding directly contradicts the Dutch claim that no evidence exists. Smedema's formal charge argues by choosing to rely exclusively on domestic denials over a verified U.S. federal judicial finding, the CTIVD participated in a cover-up. A domestic oversight body cannot legally claim a lack of evidence to deny victim redress when a foreign tribunal has already verified that the state aggressively destroyed that exact evidence. To challenge this, Smedema had to navigate the Intelligence and Security Services Act 2017. Known as WIV 2017, this act restructured Dutch intelligence oversight to separate ex-post review from the handling of individual grievances. The WIV 2017 Act created a jurisdictional split, creating two parallel lanes within the CTIVD. The Oversight Department can only issue non-binding public reports. For a claimant seeking international escalation, these reports are essentially useless. Smedema submitted his formal charges to the Complaints Handling Department because of its unique mandate to issue legally binding decisions. Forcing a binding entity to declare a conflict of interest or refuse an investigation is the only way to officially exhaust domestic remedies. Reaching the international threshold requires mastering the internal anatomy of the opponent's bureaucracy. One must target the only department capable of issuing a legally binding rejection. This strategy led to the April 13, 2026 email response from the CTIVD Complaints Department. To avoid investigating the transnational spoliation charges, the department stated the behaviors fell outside their framework because they are for yard, meaning time-barred. By citing a strict one-year statute of limitations, the oversight body can legally ignore decades of historical allegations without addressing their merit. This response explicitly formalizes the state's refusal to look backwards. It confirms the systemic, institutional blockade against Smedema's claims. The statute of limitations defense creates the specific procedural closed door needed to prove that domestic justice mechanisms are unavailable. International tribunals, such as the UN Committee Against Torture, require definitive proof that all national legal avenues have been exhausted or are ineffective. The CTIVD's time-barred rejection satisfies this evidentiary requirement, transforming a bureaucratic dismissal into the proof needed to establish international jurisdiction. This escalation triggers UNCAT Article 12, which mandates that a state conduct a prompt and impartial investigation whenever there is a reasonable ground to believe an act of torture has occurred. The case now shifts to an international venue, where the investigatory authority of the United Nations is not constrained by local statutes of limitations. By engineering a formal administrative rejection under the Weave 2017 framework, Smedema transformed a domestic dead end into the legal standing required to challenge state impunity.